We will call the first case, 106306, State versus Soto.
May it please the court, Mr. Soto appears through counsel Kevin Zolator. I'd like to request 3 minutes for rebuttal, if I may.
3 minutes is granted. Thank you.
What I'd like to discuss today is I would like to start with the supplemental briefing issues that this court has asked us to address, unless the court has any questions or wants to start elsewhere.
I do have a real quick question. Prior to the court raising harmlessness, did you raise it on the constitutional error?
Did the defense? No, we did not.
You had not raised it prior to the court doing so? The
What?
harmlessness on the hard 50?
No, we did not.
Okay, thank you.
And I'm certainly not presuming or assuming that this court will find the old hard 50 scheme is unconstitutional. It's just that I know you've had some discussions on that. And if the court would like to discuss that, we can and possibly do that later. But I'd like to focus on the supplemental. And of course, that assumes that the court would find that not submitting or having the jury find the aggravating factor would be unconstitutional. The first issue I'd like to discuss would be our contention that 21-4635, that's the old hard 50 scheme, would be unconstitutional on its face and could not be applied constitutionally if this court found that a jury must find the aggravating factor. The state has argued, it seems to me, that there are situations where this court could find that an aggravating factor, although unconstitutionally found by a judge and not a jury, that the court could find that that error was harmless. And their argument seems to be that that makes the finding of that aggravating factor constitutional, and we disagree with that, and I don't think that's the case. Somewhat of an analogy is, when the court has been asked to find that there's been prosecutorial misconduct, this court has found on numerous occasions that misconduct did occur, and then it goes to harmless error. And the court has found, well, the error was harmless. But that they don't reach a third step, and you've never reached a third step, says, well, then that means there was no misconduct. And so the way we would apply that to this case is, if you find there is constitutional error and not allowing the judge or the jury to find the aggravating factor, just because you would find that the constitutional error was harmless doesn't mean there wasn't constitutional error. So in every case, the statute says and demands that the court find the aggravating factor. So even though in some cases this court may find that that is a constitutional error, that constitutional error would be harmless, nonetheless, there was constitutional error. Because,
right, we got that.
okay. And so we think it's unconstitutional on its face and can't be constitutionally applied, again, assuming that the aggravated factor must be submitted to the jury. As applied to this case, we think the hard 50 was unconstitutionally applied basically for two reasons, and I think one reason is distinct from some of the other cases. The first, obviously, is that the aggravating factor wasn't submitted to the jury. The second is the trial court in this case specifically said he found the aggravating factor beyond or by a preponderance of the evidence. And under a lien, you must find the aggravating factor beyond a reasonable doubt. And so that has two significant impacts in this case. One, we think that absolutely precludes harmless error review if it was available. As we cited, we think it's the case Sullivan versus Louisiana, and that makes it this case have structural error because there is no starting point for harmless error.
Didn't the Supreme Court, the United States Supreme Court, essentially disapprove that Sullivan and Also and Requenco, I'm not sure how to pronounce it, but
Judge, I'm not familiar with that, Your Honor.
well, are you familiar with Requenco that we essentially in the Reyna line of cases?
Oh, I'm sorry, Judge. I didn't
Couldn't understand what I was
pronounce
saying.
it Rusinio, so you're talking about that case that you asked us
I didn't
to-
know how you was pronounced.
Okay.
Go ahead. Yeah.
Um,
Is that it, Racino?
I'm not
Anyway,
sure.
the case that allows us to be super jurors and make the finding ourselves from the record.
I think that case somewhat would agree with that position, but I think the case that this court and State v. Jones, or State v. Nelson disagreed with that, and that was a case dealing with aggravating factor where the trial judge used the wrong standard, and essentially this court said that there are no findings of fact, and this court does not make findings of fact.
Problem I'm having distinguishing Reyna is that dealt with age, which was the functional equivalent of an element. And we said if there's enough evidence, we'll just go ahead and say if the jury had been given that option, they surely would have found it. I don't see the difference here with the aggravating factors because they're the functional equivalent of the enhanced crime of hard 50, premeditated murder. So distinguish why we can be super jurors for age, but not for aggravating factors.
Well, for two reasons, Your Honor. One, in that case, I don't think, and I think one of the premises of that case was the defense never argued that the age wasn't correct. It was basically uncontroverted. In this case, we did controvert the aggravating factor existed.
Wasn't that really the application of the harmless error standard, though? Or, I mean, that doesn't really address whether we can apply harmless error, which I think is what Justice Johnson is getting to.
Sure. Well, and I guess I would go back to, and I'd like to answer that, but I'd like to start with the harmless error. We have no proposition to start with. For instance, in Ring, the trial judge found the aggravating factor beyond a reasonable doubt. The harmless error application was it harmless to let the judge find it and not the jury? Here, this court doesn't even have a aggravating factor, which has been found beyond a reasonable doubt, to start the harmless error analysis.
But in Reyna, we didn't have a beyond the reasonable doubt finding by a jury of age either.
Well, and I guess I would disagree with that case, that they could make that finding.
So you would say that Reyna is wrong.
I would. And I know that there's
And
other
its
cases.
adoption of Rasenko is wrong.
What's that?
Rasenko, it also erred in applying Rasenko.
Well, maybe under the facts of those cases, and I don't know what arguments they raised, but certainly in this case, one, we weren't told at the outset that, hey, this is what the jury's going to be deciding, or the court will be looking at years down the road on the record. It's one of the arguments that we raised, is had we known this court would be looking at the transcript of the jury trial record as to what it would have been deciding, we would have argued, differently or different trial strategy. And so that's one of the reasons that I don't know if that's been raised in those cases, is looking back now at the record to see what was controverted or what wasn't. I mean, obviously the state presented evidence in those cases, and the court found beyond a reasonable doubt, I'm assuming, that the jury would have found the age in Reyna, and likewise.
Well, can you help me here? And it's probably trying to clarify what my colleagues are asking. Let's back up a little bit. Can we, under this analysis, reach a harmless error standard? Forget about the facts of this case and whether or not it's harmless, but do we reach a harmless error analysis? I guess I need that clarified. What's your argument on that?
I don't believe you do, because I believe that it cannot be applied constitutionally. So it's unconstitutional on its face.
On its face doesn't necessarily dictate that there's no harmlessness analysis, does it? Do you have support for that? That absolutely dictates no harmlessness analysis?
No, I
Because
do
on
not.
its face is the type of unconstitutionality
Correct.
versus as applied. I mean, it's kind of a mechanism for finding unconstitutionality. It doesn't necessarily dictate whether or not it can be harmlessness, does it, as a matter of law?
That's correct. That was just our argument that we were making, is
Okay.
that because
Do you have some other arguments on that point? That harmlessness cannot be applied? It sounded to me as though your other argument is that the standard of proof problem
Correct.
is not amenable to harmlessness analysis.
correct.
That
And that was the second argument that we had, and And Justice, I know you're talking about, we can't talk about just this case. And I don't know about the other cases, if the court explicitly said he was using or she was using a preponderance of the evidence standard. But in this case, we have that specific finding by the judge.
All right, I understand the problems once we get past whether or not we apply it or not, but that's where, yeah, I understand your argument on those.
And so perhaps, it's not that harmless error isn't available in all cases. Our argument would be that harmless error review is not available in this case.
In this particular case, because of how it's framed, not because it's determining aggravating factors versus mitigating or that. If we had a situation where, let's just say, it's maybe hard to imagine, but the aggravating factors were completely uncontested. Just completely, there's nothing else in the record but support for those aggravating factors. We could then apply a harmless error analysis?
I still don't think so, only because, as we raised in the brief, I believe that the weighing of the mitigating factors is a finding by the court.
So the fact that even if there's nothing presented, the fact that the court has the capacity to weigh mitigating factors precludes a harmlessness analysis?
Yes, and I don't want to be adding facts to your hypothetical.
Well, yeah.
But like in this case where there were several mitigating factors argued for, and the trial court only found one, we believe that's a finding of fact that the others don't exist. That's a negative finding that the trial court made and not the jury. And then there's the weighing, and we believe that the reading of the scheme supports it. It is a finding to find that the aggravating factor is not outweighed by the mitigating factors.
Even if the aggravating factors are to a reasonable person, so obviously outweigh the mitigating factors, you don't think there's any room at all? As long as there's any mitigating factor, we're finished. We can't do a harmless analysis. Is that your position?
That would be my position, because I think you're entitled to have a jury make that determination, regardless of what this court or anyone believes a reasonable person would do. That you have that right, and that's what a lien stands for, is you have the right to have that jury make that determination. And I think specifically again in this case, your trial strategy may be different. If you're arguing if you know that you're going to be arguing to the same jury, the aggravating factors argument and the mitigating factors argument that is going to be here in the trial, that can change your trial strategy. I see I'm out of time.
You can continue with your
Thank you.
communication.
One of the things we pointed out in this case is at the closing, the state argued that Mr. Soto's level of participation didn't matter as long as he participated. And obviously they were arguing for a conviction. And it seems that when we get to the sentencing phase, now they're arguing, and the trial court found that Mr. Soto was the primary actor. He was the principal aggressor in this case. And it just doesn't seem that you can argue one level of participation in order to get a conviction, and then a higher level of participation at sentencing. And we've raised those issues on the brief, and we would submit those on the brief, but obviously you can see how the trial strategy may differ in there. You may, someone hypothetically could stand up and say, well, I was there, I had the knife, yeah, I participated, but I didn't do anything. Obviously maybe conceding the conviction, but that's going to go towards the sentencing phase, and you have the state's argument saying his level of participation didn't matter. We think that would all come together and really benefit the defendant at the sentencing stage, whereas here you might have two different juries and two different arguments by the state. And so we don't think that should be allowed. Are there any more questions?
Any further questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. As opposing counsel did, we will primarily be confining our argument today to the harmless error issue that was requested to be briefed by this court, unless the court has questions with respect to the other issues.
And did you raise harmlessness before we did?
We did not.
Okay.
We did
thank
not. The court has requested an analysis as to whether harmless error can be applied in the event that constitutional error is found with respect to the hard 50 cases. And I think if we go back through Kansas law and we look at how the legislature has first provided for the application in both 6261 and 602105, that when trial error occurs, that basically that trial error will not be caused for a new trial or for a verdict to be set aside or for that trial to otherwise be found unfair in the absence of substantial harm to the parties, that harmless error will apply. When we look at United States Supreme Court case law, it has applied harmless error in similar circumstances. In Netter versus United States, the trial court's failure to instruct on a material element was still subject to harmless error review because it didn't render the trial fundamentally unfair. In United States versus Cotton, it involved drug-related offenses, and the specific quantity wasn't set forth in the opening indictment. Yet at sentencing, the court made a specific finding with respect to the quantity that provided for an enhanced sentence.
Those are missing elements. What we're talking about here is if you have a unconstitutional on its face statute. And I see that different than having an oversight in instructing the jury if the scheme is unconstitutional on its face.
Well, first of all, it would remain the state's position that it's not unconstitutional on its face, that it is capable of constitutional application based on the prior conviction aspect or multiple murders, that this is still capable of constitutional application. However, to directly answer your question.
And how do you dovetail that with Gould and its progeny?
Well, I think Gould found that provision unconstitutional on its face. Its progeny started to detract from that and started to apply more of a harmless error analysis as we looked at whether...
Are you familiar with State versus Cody?
I am familiar with Cody.
And the third syllabus of that case says that where an act of the legislature or a portion thereof is clearly unconstitutional, it is the duty of the courts to so declare and to hold the unconstitutional provision or provisions null and void, end quote. I'm having trouble seeing how an unconstitutional provision that's a scheme is null and void, but we can say that it was harmless to utilize it anyway.
Well, I believe that there is also case law that says it is only facially unconstitutional when under no circumstances can it be applied in a constitutional fashion. And as we have set forth in our brief, it is the state's position that there are ways in aggravating factors that allow this statute to be applied in a constitutional fashion.
If we disagree with that, I mean, that's your premise. If we disagree with that premise, how does your argument proceed from there? If we find that notwithstanding Apprendi excluded prior convictions, that the court nevertheless has to make some finding with regard to the conviction so that it isn't self-executing, then how does your argument flow from that? If there's no way in which that statute could be applied constitutionally, make your argument for harmlessness.
Well, I don't believe, I mean, if you're going to find that there's absolutely no way that that can be applied constitutionally, then I think we have to talk about what happens to the sentence and if it's remanded, what happens at that point. I think if this court has found that there's no manner in which it can be applied constitutionally, I don't necessarily know that harmless error remains a valid argument at that point. However, that not being our position, I think if we look back at Rysenko, as this court has noted, in that case at sentencing, the court applied a firearm enhancement and found that harmless error was a valid analysis in that case because submitting a sentence to the failing to submit a sentencing factor to the jury did not result in structural error. Kansas case law has employed both Netter and Rysenko and also Cotton. In State versus Daniels, they said that the harmless error with guidance from Netter was the appropriate analysis, and in Reyna, the harmless error analysis was also employed when the failure to submit the age to the jury became a sentencing factor and allowed him to be sentenced 25 years to life under Jessica's law. That was also followed again, I'm sorry?
Go ahead, finish.
That was also followed again in Colston and Inkelar, that the harmless error analysis has been applied consistently in contexts that are similar to that which is presently before the court.
How do we deal with the weighing process, though? I mean, we may find, based on criminal history or multiple murders, that there are aggravating factors, but then there's the second step where that would have to be weighed against any mitigating factors. And how do we deal with that in a harmless analysis?
Well, I think that this court has consistently found that that's still a discretionary function by the court, that that's not necessarily a finding of fact. And so it would be the state's position that when you're looking at the harmless error analysis for cases of this nature, it's whether there's reasonable doubt that the jury would have returned a different verdict or that the outcome would have been different had that factor been submitted to the jury.
And then step backwards in the analysis. We kind of started the wrong end. But if because there is a weighing, how can on its face, how can the statute be constitutional?
Because the weighing is still discretionary. The weighing is not a finding by the court. This court has consistently found that
But even if it's a weighing, doesn't the defendant have a right to have a jury do that weighing?
Not when it's discretionary for the court.
Weighing is not discretionary. If a defendant presents mitigating factors, the court has to acknowledge that they've been raised. I mean, it just can't ignore it. In fact, I think we've found that was an abuse of discretion to ignore mitigating factors.
No, and that wasn't my point. My
Okay.
point was when the court
I
reaches.
didn't mean to interrupt.
No, my point is when the court reaches the point when he's weighing the aggravators against the mitigators, that is a discretionary function at that point.
But to engage in the process, you still have to engage in the weighing process. And what I'm having trouble with is once there's been any mitigating factors put to the jury, how is it that we can engage in that same process without it becoming not something that's so concrete before the court that there's no obvious or different resolution to it?
I'm not sure I understand your question,
Well,
Ron, I'm
we've
sorry.
said that the evidence is so strong, like in Reyna, where the
Sure.
evidence, there was nothing controverting the fact that he was 37 years old in that case. Here, if you have something that did controvert that, let's say that there was a question of his age. He was 20, no, he was 17 when we wouldn't have, that would be evidence that we couldn't reach. It has to be so strong, so obvious that there's no other conclusion that the court would have reached or a jury would have reached. Here, if you have weighing factors, I don't see how you can reach that conclusion. And in this case, we did. I mean, he presented mitigating factors. There was some weighing that went on, and I just don't see how we can engage in that process.
Well, I think it's more or less an offshoot, because I think when the court is engaging in its weighing, it's also looking at whether it's overwhelming or uncontested or substantially outweighed. So it's essentially just carrying forward the same balancing mechanism that the district court used. And I think
Inherent in that balancing is determining that something is a mitigator.
yes, but at that, I think when you're
Isn't
talking,
that a factual finding, whether his age was a mitigator or whether it was an aggravator? Or, I mean, maybe that's not a good example, but there are some facts that arguably could fall on either side.
Sure, and I understand what you're saying. That first step, isn't that first step to determine whether those factors exist, isn't that a finding? And I think when we're looking at the Alene problem, is they're talking about that finding, the use that it was employed for. Once the court made that finding, what did it do with it? And in just making that basic fundamental finding that it existed, the court hasn't done anything with it yet until it makes it part of its weighing process. So while it's a finding, it's not a finding that has necessarily had any impact on the defendant at that point. The finding that becomes problematic is when that finding is what necessarily drives the imposition of the sentence that's at issue. When we're talking about harmless error in this case and whether it applies, the aggravating factor that was relied upon by the state was whether it was committed in a heinous, atrocious, or cruel manner. And it would be the state's position that based on the evidence in this case, we have an extraordinarily brutal murder that occurred very quickly. The defendant became acquainted with his victim merely 4 hours before the murder occurred. He planned it. The victim had no opportunity to defend himself, as evidenced by the fact that there was very few defensive wounds and there were no blood on his shoes. He was killed basically in the position that he was sitting. There were 79 stab wounds inflicted, some of those so severe that they resulted in horrific internal injuries, and the coroner testified that there were dozens upon dozens of slashing wounds, which go towards the desecration of the body factor that the court found.
But the way it was charged, both as aider and abetter and principal, we don't know, or the state didn't prove, whether Mr. Soto was the one that stabbed and sliced, do we?
I wouldn't say that the state didn't prove. I would agree with that the state that we don't know which option that the jury chose, but I would certainly argue that there was sufficient evidence to establish that he was the principal actor in this case. He was the individual when Mr. Castro returned to the apartment. Mr. Soto had been alone with the victim, and he told Mr. Castro, "Don't touch anything," indicating that there's some sort of plan in place. He was the individual that was seen standing with the knife moments before the murder occurred. He was the individual that was seen with blood on his hands.
Isn't Mr. Castro the only one who said he saw him standing with a knife before he went outside, did some business, comes back in, and all this has occurred?
Yes.
But this defendant's not the only one who's in the room.
He's not the only person.
He has the knife in his hands.
Sure. He's not the only person that's in the room. And the coroner did testify that it was impossible to tell from the nature of the injuries whether anybody, other individuals were involved or any other knives were used. However, we have to look with an inquisitive eye, I guess, as to how quickly this occurred. Mr. Castro wasn't outside for very long. When he came back in, the individual had been brutally murdered. When he asked Mr. Soto why it was done, they said it was to avenge a gang killing, I think a previous gang killing, which none of them had any relation to. Also, I think it's notable that I believe it was Bradford, this case had found that a stabbing was heinous, atrocious, and cruel because there were 55 stab wounds and the defendant was boasting about it later. And we essentially have that same thing here. We have 79 stab wounds. And when the defendant bonded out, he didn't walk the straight and narrow. He proceeded to go get a gang tattoo across his abdomen from one of what they call the original gangsters in his subset, which was, our gang expert testified, was an indication that he had reached a higher level of respect within the gang because he killed a member of the opposing gang, and that the only thing that would garner greater respect would be the death of a law enforcement officer, and then proceeded to display that tattoo through various sources of social media. And it would be our argument that that is the functional equivalent of the bragging that this court found offensive in the Bradford case.
And all of that evidence came in at sentencing?
Yes.
Okay, thanks.
But what also came in at sentencing were mitigating factors that the court found. Age was the only factor, but there was other evidence of his lack of juvenile record, his succumbing to peer pressure. This was gang related. There were some other factors that were, and I just, as we would look at this case and try to look at how the court handled those mitigating factors, whether they actually rose to the level of being mitigators, and then weigh them against the aggravators, I just don't see how I'm not back in district court doing a sentencing. I don't see how we don't engage in that function.
Well, and I think that's a different question, whether you find harmless error versus whether harmless error can be applied.
Right, I agree.
And
so yeah, whether it could be applied in this case just seems, looking at that question, just doesn't appear to me that this is the type of situation where the evidence is so obvious and there's nothing controverting that evidence that we could say, well, there's just nothing else there. There is a lot here.
Well, it would remain the state's position that to some degree it's essentially uncontroverted. It was the aggravating factor was whether it was committed in a heinous, atrocious, and cruel manner. The defendant's position was that he wasn't responsible, but he didn't challenge, there was no challenge to
I see what
the
you're saying.
manner in which this,
Right, I
this
see what you're
person was
saying.
killed. So I think those are kind of two distinctly different things. And as far as the mitigators go, the defendant's actual adjudications or convictions were minimal, but he had substantial contact with law enforcement, which was consistently gang-related. He had been involved in the gang lifestyle for 2 years preceding this incident, and also while he was out on bond in this case, was involved in additional gang violence that resulted in yet another homicide and was believed to be in possession of a firearm at that time. So it would remain the state's position that it was overwhelmingly supported and that a jury would return the same outcome here. If there are no further questions, the state would respectfully request that this sentence be affirmed.
I've got one. Are you saying that many stab wounds plus boasting makes it heinous, atrocious, or cruel as a matter of law?
No, that's not what I'm saying. I'm saying
And
that
if
when
it's
you
not
look
as a matter of law, someone has to make the subjective determination. The facts may be uncontroverted, but you'd have to take those facts and characterize those, put a label on them, and does that fit into this category? And isn't that a fact finding?
Well, to the extent it is, but that's a fact finding that has been deemed permissible through United States Supreme Court precedent as well as this court when it's essentially uncontroverted and the evidence is overwhelming.
But
And
I don't know that it's uncontroverted that those facts fit that category. That's what I'm saying. If every time those facts exist, then you can label it atrocious, etc., then that's as a matter of law. Otherwise, you're applying the facts to a label, and somebody has to make that determination. And the question is it the judge or a jury?
well, and that I think that determination has been made through prior case law and has been deemed permissible. And I don't agree that there's a distinction necessarily in this case.
Any further questions? Thank you, counsel.
Thank you. Your Honor, you had caught me offhand. I wanted to go back real quickly to the Racino or Racunco case and Cotton. I'm sorry if I'm not pronouncing that correctly. And we try to brief this, and it's hard to articulate, at least for me, but I think there are some major distinctions, and perhaps they weren't decided wrongly, but they're just distinguishable. For example, in Racunco, the case, the jury found that the defendant was armed with a deadly weapon. And then the trial court came in and said that that deadly weapon was a handgun. And we try to frame that as basically the jury inherently found the basis for the trial court's finding. And he was just sort of labeling what the jury had already found, which was a deadly weapon, and just labeling it, yeah, it was a handgun. It was uncontroverted and the evidence was overwhelming. In Cotton, the jury explicitly found the defendant had a detectable amount of cocaine. And the trial court came in and determined how much that cocaine was. And again, the court, I think, found that it was uncontroverted and so obvious how much the amount of cocaine was. In this case, we're talking about whether the crime was committed in an especially heinous, atrocious, and cruel manner. And nothing in the jury's verdict inherently establishes any sort of foundation for a trial court to come in and say, this was especially heinous and atrocious, cruel manner. I mean, the jury's verdict said he was guilty of first-degree murder. That's it. That's all the jury's actual verdict establishes.
Would the difference be an objective determination versus subjective? Because a weapon is either a handgun or it isn't. Drugs either are this weight or they aren't. But 79 stab wounds may or may not be atrocious, heinous, atrocious, or cruel.
And I think and I agree with that. And I think that's I mean, sort of how we put it, I think we said that, you know, it's not inherent and there's just no objective evidence that supports this foundation for the trial court to come in and say, okay, we didn't ask the jury to find that, but I'm going to go ahead and look at the evidence, and it's so clear, so obvious, so uncontroverted that I'm just going to go ahead and fill in that gap where we didn't ask the jury to do so. So I think maybe they weren't decided incorrectly, so I wanted to correct myself. Maybe they're just distinguishable for those reasons. The other part,
So your argument is here that it simply isn't like those cases because this evidence was not uncontroverted?
and similarly in Reyna and Daniels,
In Reyna, right.
those cases are talking about the jury's verdict wouldn't be different. And I would equivalent the jury's verdict in those cases to the finding of the aggravating factor. The jury was never asked to find the aggravating factor, and it's not like the court didn't define one of the elements or give them the wrong standard, and then this court is saying, well, the jury would have found the aggravating factor regardless of the error. And that's what Reyna and Daniels in those cases are talking about, is that it would be, may I finish?
You may.
Is that it, you know, it wouldn't have been disturbed, you know, it would have been the same finding. But in this case, it was never submitted to them at all. The finding of whether or not this crime was committed in an especially cruel, heinous, and atrocious or cruel manner was never submitted to the jury at all. So I don't think there's any way to look back and say, well, absent that error, the jury's verdict still would have been the same. I mean, the verdict for the finding that he committed the crime would have been the same, but not the aggravating factor because they never actually determined the aggravating factor.
Any further questions? Seeing none, thank you, counsel.
Thank you.
Both for your arguments this morning. Court will take this matter under advisement.